Things are going to start happening to me now.
You've done all the reading. You're a scholar. You're a professor. You've done all the reading. You've done the intellectual heavy lifting.
More or less, eat shit and die.
You wouldn't know a fact if it begged you all night long.
Want to give the wrong impression, because I am very high.
Ran up behind him with a hatchet. Smash, smash, smash. Yeah.
Care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen.
That was the perfect answer. Thank you. That was...
And welcome everybody. Libertarian Podcast Review. We've got Andy. We've got Andy's daughter. It's a crazy night. We've got sovereign citizens, the Darrell Brooks trial. We're going to talk about a bunch of things. This is Tyler Yonke, Garbage Maine, and Emma. How you doing, both of you?
What up? What up? You want to say hi, Emma?
Hi.
Hello. There we go. Oh, adorable. I don't know how the one comes from the other, but welcome.
I just help Larry.
Right. That's what I ask him every time, too.
Go get your stuff.
All right, we're very family friendly here, so yeah. Did she just want to come on and tell us about sovereign citizens?
She's looking for a coloring book.
All right. Is that what's we've got on a Saturday night for kids nowadays? Is coloring?
Yeah. Wholesome activities.
Wholesome activities. Okay. Well, welcome, Andy. What do you think of my title, and what do you know of sovereign citizens? What do you know of Daryl Brooks, the trial? And let's start with that.
I don't know much of anything about sovereign citizens. I know I've heard the argument from some schizophrenic people. Yeah. Daryl Brooks seems to be schizophrenic, and I know he ran over those kids in Waukesha, but that's about it. Yeah.
So I don't know if have you watched any of the trial?
I've watched like 2 or 3 clips, so I haven't watched much.
It's insane. Okay. Every day it gets worse and worse. And I'll play some clips here. We'll just take our time on a Saturday night.
Can't hear the TV in the background, can you?
No, not really.
Okay.
Yeah. So it's insane. And I thought we'd walk through some of it and then talk about, why he's doing this sovereign citizen, the whole gamut. And so what made me actually think about this was I was watching Nick Rekieta. He's doing the live stream, and there's a public defender on there from Florida. And he's like, look, he talked about sovereign citizen. He goes, there's this sovereign citizen's survival guide to court. He goes, I've read it, and this is exactly, he's following the playbook. And what he's doing in here is exactly what is part of that. So I read it, and I'm like, well, not completely true. So we'll take some of those things. First of all, how have you been?
I'm holding up, dealing with some family issues. So just pray for me if you can. Pray for Emma. And okay. I don't want to speak too much on it, but
thoughts and prayers, right?
Yeah. It's some kind of serious shit going on, but we'll get through it one way or another.
Yeah.
And happy episode 69. You're gay.
You're right. Happy episode. Yeah. So I was just earlier, it'll come out on it's Unfit Statesman's podcast. Zach Brown. I was just on there with he and Quincy. Now it's audio only. Unless I think in the Patreon announced, I'm not sure if he does video on that. If it's video, it would be just amazing because it's me and then Quincy's shirtless with like a shower cap or something. Fantastic. And so it was about nothing other than talking about race and some other things. So that's good stuff.
Quincy's got a larger than life personality.
Yes, he came on there. I think we combined on ass eating. There's some overlaps in our lives. That making money, but all we had.
You guys both get your essential vitamins and nutrients.
I guess. We probably have different ways of doing that too. I'm probably not as brave as he is. He seems to have no discernment as to what he's doing.
A cultural technique or something.
I think so. Can you imagine just the sound effects from him alone would be.
I don't want to imagine. Yeah. Okay. So what are we looking at here? Daryl Brooks.
Daryl Brooks. So it starts off. He's he runs over a bunch of people in a parade in Wisconsin, kills 6, injures a bunch, and he decides to represent himself. Okay, so he's put up there and said that he is a sovereign citizen. Okay, and you look at the sovereign citizen stuff. It's a lot of it's almost the idea of a voluntarist society, yet still grasping to the Constitution, right? Like I'm an ANCAP, but I'm not an ANCAP because I believe the Constitution rules everything. So I'm still under that. So the big deal is about jurisdiction. Okay. And and probably like their overlap with the ANCAPs would be the 14th Amendment, which codifies all the other amendments from the federal government. So it gives you due process, First Amendment for everybody in the states, that kind of thing. They basically say no go on the 14th. And then their big one is, and then we'll go through this guide here, is not substantive due process, subject matter jurisdiction. Okay. So courts have 2 types of jurisdiction, personal jurisdiction in persona, like you're over your person, like for me, right? And then subject matter, which is, criminal, civil, blah, blah, blah. And most courts in a state are what's called general jurisdiction. So like the Superior Court or Wisconsin, the Circuit Court, they're under their Constitution. It says, I don't think it says plenary of that. And basically anything under the sun of the courts. So did it happen in your area? Did it happen in your state? Then they have jurisdiction over you. And now, so he goes into admiral, because the Constitution lays out admiralty law and other kinds that the federal government has specific jurisdiction over. But states have jurisdiction over everything else. So you go to your court and you're like, oh, so he's always asking, he keeps saying, you have to prove, and by the way, he speaks like a total genius. You have to prove subject matter jurisdiction. She doesn't have to prove it. You can raise it. So you and I get into an altercation. You file here in Sacramento, and you file a case in Texas. I would say, well, okay, one, you'd have to personal jurisdiction to be able to get me somehow. And then you also be like, well, it didn't happen in your state. So, and it wasn't a federal issue, so you can't just file it in a federal court. So you don't have subject matter jurisdiction. I would say you don't have it. And then they'd go through that process and say, you're correct. And they'd kick it out. Okay. That's one way. Now he's saying you have to prove that you have subject matter jurisdiction, which is a little bit different. She doesn't have to, she just has to, well, it's in our state. And you can say, you don't have jurisdiction over me. And then she's like, well, I did, because Waukesha is literally right here. You killed these people right here. Anyway.
So is that considered so I'm the legal layman here. You'll have to break down a lot of this stuff for me. Right. Is that what's considered in personam?
So that's the person over the person. So he ran over these people and they file, they filed the suit against you. You're like, well, you don't have you have to have personal jurisdiction over the person as well. So that's part of it as well. David Brady says, what's up, Tyler? I'm sorry that he didn't mention you, but anyway.
I don't even know who that is.
Oh, there he is. My favorite Southern man.
Oh, what's up, David Brady? Yeah. I've been listening to, just a quick aside note. I've been listening to some Brian McClanahan talk about the 14th Amendment and how basically the Constitution changed after Lincoln. It's a whole new constitution between substantive due process and procedural due process. But again, I'm a legal layman.
Substantive due process? That's the big issue. Okay.
Yeah. I mean, I'm the legal layman. I care more about the history stuff, but I try to pick up what I can.
So the in personam or personal jurisdiction is kind of what they call minimum context. So for him to, as an example, they're filing this and they say, does the court have jurisdiction over this person, not just the subject, but the person? So this is often comes into play where a person is trying to forum shop and they're going to say, I'm going to file this case. I live in Texas. I engaged in a contract with Tyler, who's in California. Now, does the state have enough? Is there enough contacts with me in California for you in Texas to actually say that they have jurisdiction over the person? Right? Because the forum is the correct place. Well, that's not even an issue here because he's in Wisconsin. It happened in Wisconsin. He was driving in Wisconsin. all the personal contacts, it's not an issue there. So he's now, and by the way, this is the big deal with the people. Jackson is greater than Lincoln. You're derailing us here. I don't know what that means. Percy Jackson. Andrew Jackson. Anyway, so jurisdiction is a big, and we'll walk through kind of this thing there. So does that make sense then? The two different types. Okay. Okay, and the reason they raise this is because the Constitution itself has specific kinds of jurisdiction for the federal government. So the sovereign citizen type of person, when they go through their guide, they really work this one over, and it doesn't work. Just to tell you.
Yeah, I think I've heard some schizophrenics use this as like you're not an your name is like registered as a corporation or something schizophrenic like that.
Right.
Or so, some kind of like maritime law or some
yeah,
shit.
admiralty law, right? So they do say that, and he'll say it all the time. So when he's on the stand, every witness comes in, he starts saying things like, "Who do you know who the plaintiff is in this?" I'm sorry, I'm doing an ebonics. I can't even do a good ebonics. He's so bad at it. You know who the plaintiff
so white.
is? Right. And the court always objects and says you're not allowed to do that. Because he says that he had one of his witnesses he was going to call was the state of Wisconsin. And they're like, well, that's an entity. And he's like, exactly. That's what I'm saying this whole time. You got to be a person to bring a case. And they're like, no, that's a civil case. This is so he's got all kinds of these problems. Yeah. So let's see if we can find, I want to see here, play him saying when he wants to defend himself, and then we'll start here on that. Oh, that's the wrong one. Okay, so keep. Do you have any other questions on that?
No. I'm just gonna fly by the seat of my pants, and I'll ask questions as they pop into my dumb brain.
Okay, I'm kind of flying by the seat of my pants too. I thought I had it, and now I can't find it. I was also gonna do. So one of the reasons I wanted to talk about this was to the judge, and we'll go over some of these things. If you've seen any of the clips, it's him and the judge going at it, and it's insane. And I kind of want to, why is she allowing this to happen? Well, one, he's okay. So what?
Real quick, I got one quick question for you. All right, what in your purview, like if you had to put in a percentage amount, do you think he'll get off on some kind of clerical error?
Right. Technicality of some sort. So that's my point of saying this judge is over the top. She's bending forward and backwards for him. And she's actually removed him from the courtroom into a different courtroom where he's on live stream over there. And then she mutes him when he won't shut up as well. She's doing everything she can so that when it comes to an appeal, there's not going to be a problem. Okay. And so there's this case called Illinois v. Allen, I think, and it was about binding and gagging a person that was basically self-represented, who was very unruly in the courtroom. And
sounds like a fun night.
Right. And it says you can do 3 things and up to and more. Okay. So it gives 3 examples, which is like holding him in contempt, put him in, binding and gagging him, doing it in absentia and or more. And she's like, well, I'm not putting you in. This guy has nothing to lose. Okay. You put him in contempt. What's that going to mean? You put him in prison. He's already, get 6 consecutive life sentences. You fine him. Okay. How are you going to get the money? So he just says what he wants, and he wants a contempt so he could try to get something. So I don't think it's going to be overturned because she's doing everything she can to, she warns him and has arguments with him like he's her ex-lover, but it's outside the presence of the jury. So you got that. Anuradha, you have a great show. 10 out of 10. Oh, thanks. I appreciate that. It comes a lot from David Brady. Okay, let me play this part. This is when he was still represented, and he decided to go on his own. Share screen. We'll play a few little clips here of this. And let me know, once again, as we always do, Andy, let me know if you can't hear it, okay?
Explain to me that request.
I got it. I can hear you.
Said it on record.
Loud enough?
To represent myself
You probably
as
want.
a sovereign citizen.
I can't really up it anymore.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are, other than you are accused of 77 counts, which I will go through momentarily, and you have the right to have an attorney represent you. That's your constitutional right. You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
What don't you understand about that, sir?
I don't understand why is a reference being made to the capableness of my attorneys. Now, I agree that they have worked tirelessly on a lot of the things in this case. And I credit them with that. I'm appreciative of that.
Okay, I might have gone
I'm gonna
past
make
the
a
part of let's see
determination,
here.
sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are, other than you are accused of 77 counts, which I will go through momentarily, and you have the right to have an attorney represent you. That's your constitutional right. You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
Much, it looks like.
I muted you just a tad bit because I was hearing your daughter's TV there, which is fine. Don't freak out about it. So I did miss the part there. He wanted to start about whether he was pro se or pro per. Now, do you know the difference of that? Because she kept asking him if he knew the difference of that.
Pro se and pro what now?
Pro per. He said he didn't want to be pro se. He wanted to be pro per.
No, I don't know the difference.
Okay, which is kind of what we were talking about. And you go through the guide, and we'll walk our way through some of it here, which is the Sovereign Citizens Guide says you want to so in different jurisdictions, it's pro persona or pro se. Basically, you're self-represented. You don't have an attorney. And one is basically without an attorney, and the other one says I'm representing myself as a person, and then one says I'm representing myself as an attorney. The Citizens Guide says if you represent yourself as an attorney, you are now consenting to the court's jurisdiction, and therefore you are under their rule, and you should not be consenting because you never consent to their jurisdiction ever. I wish I could play this part.
Right. Good afternoon.
Is there
of that on?
Go ahead.
Does this type of legal argument does it work ever? The sovereign citizen argument?
No, and I'm going to actually play a clip here of I had a news shot of them actually going over that with another legal person, an attorney. I can't find it now.
Get your
I had all these
together,
set up for
Tyler.
today. I had all these set up for today.
So I was just curious because I'm wondering if part of this survival guide also like part of requiring or to make this sovereign citizen argument requires you to renounce your citizenship. I don't know.
No, he's a citizen of the United States, but he's not quite what you think. Okay, here I'm finding it.
Which I mean, I've looked into that a little bit. It seems the renouncing your citizenship seems a little funny because you have to pay to renounce your citizenship, but I don't know how it would apply or if it would apply to this as far as renouncing your citizenship, staying here and claiming sovereign citizenship.
Right. Okay. So let's play this one.
Claims he is a sovereign citizen, and today the judge ruled Brooks will not be able to use that as a defense because it does not have merit. Ben Jordan goes in depth on what a sovereign citizen is and why the defense has never worked in a criminal case in the state of Wisconsin.
A sovereign citizen is someone who believes they are not under the jurisdiction of the federal government and therefore thinks the laws don't apply to them. A local civil rights attorney says it's an illegitimate defense.
Mr. Brooks, you're interrupting me yet again. All right.
Among Darrell Brooks's many outbursts at trial, he suggests being a sovereign citizen means he's immune to the rules of the court and the laws in Wisconsin. From a legal standpoint, what does this mean?
From a legal standpoint, it means nothing because it's not a defense at all.
Milwaukee civil rights attorney William Sultan says that's because the concept isn't recognized as a legal defense in any courtroom in the United States.
It's a theory that has been rejected for decades, and the court properly rejected it here.
Williams says the unusual defense has gained steam and become more common over the last decade. Have you ever seen someone try to use this sovereign citizen defense here in Wisconsin?
Yes, there was a case of some notoriety about 7-8 years ago with an individual.
Let me ask you this, Andy. So you're going to do an interview with someone. Why do they, why are they walking down the road? Why can't they just talk to them like normal people?
Yeah, this is some just news people giving themselves extra work.
Right, and he's walking ahead of him, and the other guy's walking slower, so he keeps having to look back. Anyway, so
would put false liens on some judges in Milwaukee and Waukesha County. His case ended up being moved to Dane County, and he did pursue a sovereign citizenship defense.
How did it work out?
Not well. He was convicted.
Dr. Christine Sarteski is a professor at Chatham University who's closely monitoring the Brooks trial from Pittsburgh, Pennsylvania.
A lot of people have never seen a sovereign citizen or have heard of the defense. I've been tracking them for a number of years now. I have I wrote a book on them. I have a website.
Dr. Sarteski says the sovereign citizen movement has been fueled with falsehoods on social media and the internet.
People always ask me, well, why would anyone try this when they never work? But the thing is I don't think the people who are trying them know it doesn't work. Or they might believe, hey, if I just use my strategy, this little difference here, it will work this time.
Not only does Dr. Sarteski say the defense is ineffective in the courtroom, she says so-called sovereign citizen extremism poses a threat to law enforcement.
You add in somebody who comes in with these, illegitimate ideas that have no basis in law, but they really believe them, so they then fight with the officer. And this has led to sovereigns being shot at traffic stops and including, officers being shot.
Dr. Sarteski says a sovereign citizen defense never works out in the end, but it can cause major delays in trial due to constant objections, similar to what we've already seen in Mr. Brooks' case. Reporting outside the Waukesha County Courthouse, Ben Jordan.
And there you go.
For the record,
Okay, so what did you take? What was your takeaway from there?
I mean, I got kind of the gist of it. It seems, I'm happy if people want to fuck up their own case, whatever. By all means, I took away that people are schizophrenic and it showed Twitter. It's like, this is your portal to schizophrenia.
Okay, let's play some of these clips here of what we got from him in the courtroom.
I'm not sure what the terminology for that is, but that's how I would take it. That's a subpoena.
No, that's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something, which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
Something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions for this witness? Please ask them. Would like to get to one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks,
telling them the truth.
stop.
Yeah.
I'm putting you on notice
that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back in
Prove it. I don't agree to a
He
stop.
seems to be proving it himself.
Right. I don't know why there's no sound on this part. So what's hang on a second here. We'll go back to that. So what's interesting there is, and I want to play just a few more of these outbursts, and then we'll go, because once was it Obama that did the red line with Somalia or one of those other countries, and then he's like, you could just go over it all the time, and then he's like, it's fine. She's drawn a red line. This is the last time, except for the next time I say this is the last time. So what you saw there, and then she just runs off. I know she's exasperated, and this guy pushes her buttons constantly, and you can see why he's such a creep, and that he just thought he should just run people down by his behavior. So
yeah, he looks like a habitual button pusher.
Right. Does the flag behind her say raccoons? I don't know. Take a look at that. We'll get to the flag, because that's a big part of the sovereign citizen deal. Is the gold on the edge of the flag. You're not supposed to, that means something. I don't know what it means. Maybe it's a Jewish thing, but it's big on that one.
He's not allowed to acknowledge the gold on the edge of the flag or something.
Yeah, I don't know. Here we go. Let's do some of the wildest moments.
Interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
The trial for Darrell Brooks, the man accused of driving through the Waukesha Christmas parade last year, killing 6 people, begins, and Brooks is representing himself as a sovereign citizen.
As a retard.
I'm Anjanette Levy, and welcome to Law and Crime Sidebar Podcast. Darrell.
Okay.
But also, you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect,
he says that all the time, like he's
I do
Ricky
not
Bobby.
agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
And
skip forward,
that's the
and then
very basic in every
takes his
trial,
shirt
in
off.
every case where the defendant, the number one, they
Okay, I don't want to play these people
He's
podcasts.
shirtless in court.
Right. So
I respect that.
Right. He's let's I want to get to one last yelling match between them, and then we'll go on to the actual sovereign citizen survival guide for those that are interested, because I think as ANCAPs and whatnot, we should be ready for this. By the way, he brought this lady on, and he brought this lady on because he started calling his own witnesses. So he brings her on. He's asking her questions that I don't even know what they have to relevance to do. And by the way, he objects to everything. Grounds. That's his answer for everything. It doesn't make sense. So you put someone on the stand, you can't do leading questions. Okay. You have to ask. And then, but when you do cross-examination, you can do leading questions. So there's that, and he's objecting, leading, and they're like, well, it's on cross-examination. Objection, leading, well, it's on cross-examination. And typically, and the judges even said this, they'll go, hey, we'll just have a standing objection. I understand, just for the record, but he insists on saying it every time. You had to spend a little bit of time in court, right?
Yeah,
I mean, for
just family court.
When you were in there, did you yourself have any issues with the judge, or did you see other interactions? I could tell you some fun stories about interactions with the judge, but did you have any of those?
never made it to like a trial because all of my character witnesses were subpoenaed at one point, and they all showed up, and now there's a full courtroom of everybody waiting to see the judge, and we sit down. There's for like 10 minutes. We kind of go back and forth about, you know, what the mediation was or what has been going on, and the judge just, he was a Berg or a Stein or one of the Steen. And he said,
German. Got it.
Yeah. He said, I'm not going to hear your case today unless you want to stand up here and tell all these other people that they're going to have to wait. Like talking to me like that, which I thought was like pretty fucking gay. Like, you subpoenaed all my character witnesses. We're all here. We're set to go to a trial today, and now you're just kicking it back.
I said to the judge once, and let's play this, and then I'll talk about some of my experiences.
Without having that letter.
So
The state has the ability to question you about that, or question this witness. And
Let me set this up, because this is actually kind of an important deal. So he brings his girlfriend on, who kind of the whole thing I think started with her, and he was getting in a fight with her, and then tried to run her down, and then was pissed off and just took out for this.
Yeah, I
hang on,
remember
we
that.
got a question. Hey, Andy and Tyler, hope you're doing well. Sending Andy my best wishes. Yeah, and some thoughts and prayers. Come on.
Thank you, Lorenzo.
Yeah, no, exactly. So he brings his girlfriend on there, and now there's issues about pre-existing criminal acts, whether to bring them in or not. So there's when I think he had an attorney before he went on his own. They made motions, and they were excluding any of his past violence records. Okay, so he had actually. We're going to hear it in a little bit what it is. So he brings the baby mama up there, and he asked her, you know, by the way, you're not supposed to call him Daryl because he doesn't consent to that use of his name. So I don't know who this is, but they're like, I don't know why you brought her up there as a witness.
So the judge is excluding his prior.
Yes, she had made an order saying you can't talk about his prior acts of domestic violence, you know, whatever it is. You can't bring that up. So she had been very careful with witnesses that came up to testify, you know, for the state about not letting them talk about those things. She was very, you know, concerned.
Yeah, because you have to keep the case narrow, right? Like,
right.
You want to focus on what the case is about.
and since it was his motion to do so, you know, you don't let that happen. Now, there's oftentimes, as an example, you put someone on the stand and you question them. Then whatever you've questioned them about, the opposing party, when they do a cross-examination, they could only question them back, you know, on cross about what you brought up. Okay. That's about the scope. Okay. So if you happen to talk about something that they weren't really going to talk about, or that had been excluded, maybe, you know, depending on what it is, you've opened the door for those kind of conversations. So they had excluded these things. All right. Already. Now he brings his girlfriend on, and she's not happy about him. I don't know why he brought her on. So he's asking her stuff. And then she says, oh, I haven't seen, you know, you in quite a while. So he wanted to bring, now it's called impeachment evidence, which would be to show that she's not truthful. He wanted to show that I got this picture. You sent me this picture in the mail to show that she had actually been in contact, which the picture was of their child. The judge is like, no, you can't bring that up. We've already, we're not going to do it. First of all, she's like, let's get this picture. How do I know that this picture was sent from her? Okay. It's a very simple question, which all you would have to say is, well, I got an envelope and it was addressed to me from her, signed by her, and this picture was in there. The judge would have been fine, but he likes to be ostentatious, just a total jerk. So this never happens. Right. So then the DA comes on and they're like, here's why we shouldn't be allowed to let it in. And I think this is where it gets pretty spicy, and I enjoyed it.
to look at the veracity of what your claims are here. So when I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
Yeah, he would have to submit it to evidence, right?
Do you have the letter with you in court?
Yeah, you got to authenticate stuff. So yeah, and she's trying to, without doing it, telling him how to do it. How do you know this was from her? because I got it. That's kind of the funny.
I just said no.
Well,
How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it.
Yeah.
Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And
yes,
everybody
we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
try to
it's not a tactic, it's
what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts. Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom.
There we go.
I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that
I'm not
because
done.
that's a lie. Because at the end of the day,
Let
if
him
we
finish.
don't open the door on
Let the white
you
man
wanna make
talk.
a record and not be accurate. So let's be accurate all on the record since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on
being
we can
loud,
open the door on how old she told me she was when we met.
interrupting.
There you
Ask
go.
that question
He is
to me.
How old
over
she
the
was.
top
Ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right, under Illinois versus Allen, I warned him repeatedly, he's being removed from the courtroom. And you know what? Let me dial that back. We're just gonna take an early lunch, 1 hour, we'll be back, and unless he brings that letter, and he
Don't
can
sit
show
here and try
it
to
is
think you know what's
inadmissible,
going
she will
on.
not be questioned, and under 90611, I will
You don't
declare
talk
the
about
cross-examination
you don't know where,
closed.
You don't know where, what
Thank
happened
you,
at
we're
the
in
time
recess,
for all this
1
happened,
hour.
bruh. Get your facts. So let's open the door on all of it then so we can get all of it on the record. Since you think you know so much.
All right, so he said she was 18. Andy, what's he supposed to do? In a free society, someone would have taken a well-placed vax at him and stopped this before he even got started. Yeah, so it's a sad story. He also brought a lady on there to testify. Once again, I don't know why. On cross-examination, I couldn't really understand what his line of questioning was. And then on cross-examination, they asked her if she kept talking about being there with her kids. And so then they're like, did anything happen to your kids? Yeah, all 4 of her kids got run over. They didn't die, but they were severely injured. Yeah. And I was watching this on Nick Recado's stream, and then he put up a GoFundMe, and it went while he did this from like 60,000 to like 85,000. And I donated a little bit in there too. So good for her. But it's almost like just bringing people on to torment them further. Okay, let's get into this survival guide. What's first of all, your feelings as to Mr. Brooks so far, and the judge? Even there, she's like, "I've had it. You know what? I'm just gonna leave." And then she doesn't really. She finally did remove him, but warning after warning after warning. So.
Yeah, the punishment won't be enough. That's how I feel about him. He's clearly mentally handicapped and schizophrenic.
Right.
I wish this trial would just be over and they would tell them to face the wall. But it is entertaining. And I hate saying that, but it is entertaining.
It is entertaining. And there's a few things to learn from it, which is, one, he hasn't at all, there's an intent that has to go along with first degree murder, right? And I think that's what he's been charged with, 70 some counts of everything. His opening statement, I mean, we can even walk through that. It's, 9 minutes of him, then he's crying. People are misunderstanding. There's people hurt on both sides. And, the typical opening statement is like, okay, here's the case. Here's how it breaks down. My client is, how I would say it, my client is going to show through evidence, and you walk through, this witness is going to show this. This one's going to show this. And you'd all break down that, intent. I mean, he could go from intent on these things to, except it's hard when you start hitting one person to, and you don't slow down and you're swerving to hit more, that it's a problem. Magoo, I can tell you why Daryl is doing what he's doing. He's retarded and makes a perfect case for public execution.
Yeah.
Wow. There we go. We're going to get axed off of this. He says axed a lot. I believe he means asked, but I don't want to presume anything. So we'll just go through some of these highlights here. This is a survival guide offered as educational material only. Okay, I don't need to tell you. There's a lot to this guide. The fact that you've attained this guide suggests that something has gone awry in your path of sovereignty. Either you have been able.
This?
I don't know. It's a survival guide by FP. What is it? Freedomschool.com. So there you go. A lot of it is about court case, the traffic tickets and stuff. Keep your survival guide in a safe place where you can easily get to it when you need to. Maintaining a complete kit is vital for showing. Now, by the way, that lady, she said she had a website and she wrote a book on sovereign citizens. You look at them, they're not necessarily dangerous. So, this guy's maybe an outlier. I know there's the Bundy. I don't know if those guys, Eamon Bundy, on their BLM property, not Black Lives Matter, but Bureau of Land Management.
Yeah.
There was a standoff. I think they were, in the right on that one though. So,
did they use this sovereign citizen argument or no?
I don't believe so, but I think they'd get grouped into them. So I'm coming to it a little late. Is this idiot a sovereign citizen? Well, Lorenzo, he's claiming.
Who is it?
He's Yakum told him to do it. He claims to be a sovereign citizen, so that's kind of his defense. And this is what this guide, and I'll put it in the show links, by the way, at some point. Important, more knowledge of these techniques and truths will not be enough. Just by mentioning such things in a court will not, of itself, help you win your case. True. A piece of paper is not by itself an automatic shield. Constitution, people. You cannot depend on the court or police to correct itself. It is up to you, we the people, to detect and demand correction to the court's errors and fraud. You must be able to think on your feet and stay on top of each argument as it comes down so that you can logically steer the judge into a corner. That's what it's all about here. You will be going head to head with judges who are very slippery. Okay, that seems kind of a racial thing, anti-Semitic even. Or you may be ignorant as to the real law and how fraudulent the system of justice is, and you will have to do your homework. Completely true. So here's what you need. We're going to start. This got me. I was like, excuse me? First thing you need, it's 0.0, not 0.1, but 0.0. The flag.
We're starting with nothing.
Right. A small U.S. flag on a stand, but no gold fringe. This is your basic proof and exercise of your status and rights in court. You will bring it with you and set it on each table or bench where you stand, wherever you are going to directly challenge jurisdiction. Right there, I was like, wait a second.
What does this have to do with anything?
I don't know, but no gold fringe. So if you look at the sovereign citizen info, and I think I have a little bit about it. I don't know where it's at here. I had a whole deal on it. Basically, they say that the gold fringe, I don't know what it has to do with something. So it's, it's
that the America is a corporation thing?
Perhaps. Let's look it up here. Sovereign citizen flag. There's an L in that, right? Gold fringe. Okay. Tax protesters, conspiracy, a dictionary. Okay. Why was J.J. McNabb sovereign citizen twat? Okay. The stupid pro se legal theory making the rounds. Okay. Okay, here we go. Is it true the gold trim in the United States flag signifies that one is in an admiralty court and therefore can be deprived of their civilian rights? That's what it is. There you go. Admiralty court. Okay. So you had it. It's a court of the high seas. Is that what we're looking at?
Yeah, some fucking maritime law shit. Right. Some international waters court.
All right, so these are the things. Your personal licensed court recorder. Okay, that's not bad. I mean, having a court reporter, just someone to take record. We can often get our own. We go through the courts on some, but you can always hire your own to do it. So,
a
totally
stenographer.
Fine. Yeah, exactly. Legal counselors. So I'm reading some of these things in here, and we want to, just from what you've seen with Daryl, I didn't see a flag. Okay. I also didn't see that he got a personal court reporter. He's talking about everything on the record, though. Andy,
well, he probably can't. He probably can't provide a flag, right? Because he's in custody, so it's not like he can just bring a flag.
Maybe that's why he's losing.
Once the judge sees that flag on his
She's gonna
desk,
freak the fuck out.
Legal
Legal counselors. These are people just to sit beside you or behind you, not licensed attorneys. They're helpers. The more, the better. Okay. True copy or original paperwork, which that's fine. But yeah, he's been weird about this. I want a verified copy. By the way, he's read some things, so sometimes he makes some good arguments because he's read some things. He asked the judge something and she wouldn't answer because she was just tired of this shit. So he had read the word tacit the night before, but he didn't realize that it was pronounced tacit, and he kept calling it tacit. That's a tacit. That's a tacit consent. Yeah, I'm like, what?
So he's probably getting some legal advice from some jailhouse lawyer. You know what I mean? Who's some guy who's locked up with him, who's telling him, "Yeah, dog, do this shit. We got you."
Right. Copies of all relevant
schizophrenic person.
Right. Copies of all relevant laws that apply to your case, photocopies of statutes, codes. Okay, he's got access to that. However, he keeps reading the Bible. So he's got the Holy Bible there, and then when he gets sent into the other room and she's talking, he stands up and just reads the Bible like he's not listening to her. Wait till it gets to that commandment that thou shalt not kill. Murder. Survival guide, that's number 5 on the list. But remember, it's actually 6 because 0 was there. So a pen and paper, pocket tape recorder, unlicensed. This is unlawful. You can't do your own recording, so it does want you to do that. You should always represent yourself in appropriate persona, in your own person or proper. This also qualifies you as an attorney. In fact, according to Black's Law, and they go into some of this. And if anyone tries to intimidate or deny you your rights by asking if you are an attorney, you can always reply, "In fact, I am." Bring your own flag with you wherever you appear in court to show your sovereignty. By representing yourself, you are free to expose any of the many fraudulent deceptions and procedures being used against you. So here's part of the problem, which I get. Okay, so they're saying you're not upholding the Constitution. Totally practical. I think that's a problem with the courts and a lot of times. But they also, but they want the Constitution, right? So they say, I haven't agreed to your set of laws, but I've agreed to the Constitution. They're almost to Spooner, Andy, but they're not quite there. Because Spooner would say, you didn't even consent to the Constitution. Why are you okay with the Constitution, but you're not? If you're okay with the Constitution, you should be okay with these next set of laws, right?
Yeah. Well, this might piss some spoonskins off, but the Constitution is not an explicitly anti-slavery document. I know a lot of the Spooner heads believe that his interpretation that's what it is, but it is not.
That the Constitution is anti-slavery?
Yeah, that was Spooner's belief, that it was an explicitly anti-slavery document.
Okay, so what is it? An explicitly slavery document, though?
It's neither, but the argument that it is a pro-slavery, yeah, the argument that it's pro-slavery has more weight to it than the argument that it's anti-slavery, but it's really neutral. It was meant to protect property rights, and at the time, slaves were property. So there's the Fugitive Slave Act and shit.
So what's your argument that it's pro-slavery? Slavery.
Well, it was just, Yeah, David's right. It's ambivalent. The Congress can't institute slavery or abolish it, really, when it was created, you know? So it's really neutral on the subject. But, I mean, it was because it was meant to protect property and slaves were regarded as property. That's why the argument that it's pro-slavery holds more merit than the fact that or Spooner's argument or interpretation that it's anti-slavery.
All right, cool. Hey, by the way, people, we're gonna go for a while tonight. It's a Saturday night. What else you got to do? I don't know what used to be on TV when you were young, Andy. For me, it was, well, my parents would start with like Lawrence Welk, which I hated. Then it would maybe Hee Haw.
Hell yeah, let's go.
There would be a round of The Love Boat, and then Fantasy Island, and then some local news, and then we'd start in with Benny Hill. Or Saturday Night Live, and then Benny Hill. Solid. That was a good night's TV. So this is what we're doing here, people. The basic strategy in court appearances always is to use the best, most effective, and direct strategy up front at the first court appearance, so that the case is dismissed, i.e., we win. They keep talking about you're going to do this, and then it's dismissed. They just keep saying that, like the judge is like, "Holy shit, his flag does not have gold." We are out of here.
Yeah, I haven't heard him like in any of the clips that I've heard him. It doesn't sound like he's talked about the case whatsoever at all. He's just talking about procedural and clerical shit. It's not like I'm not guilty because someone was the KKK was chasing me and I was trying to get away from them or something.
And by the way, the DA has done, I think, an exceptional job of just like being very plain and simple, because the facts will just say everything for him. You let him be the crazy person, and then all their witnesses are doing they're not trying to outsmart him. You don't need to do that. You just need to answer yes. I always tell clients, I'm like, especially on cross or when or direct, if they call you, you're a piano. So if they push one note, one key, I only want to hear one note. I don't want to hear a song. So if they ask you yes or no, just answer yes or no. I will correct it if we need to go through there. So anyway, the witnesses have been doing a really good job of that. They're just like, here's the deal, because it's plain and simple, and it's hilarious. Did you see who was in the car? Like people are like, well, it was you. Oh, okay.
Is he in the courtroom with us today?
Yeah. Exactly. Can you point him out? It's another game, no more, no less. Very much like poker. The stakes are essentially your freedom. And look, I agree with some of the stuff. The court, the money. It's like I do feel like an ANCAP society and voluntary is the way to go. But I know where we're at. You can't, as Pete would say, living in Ancapistat in your head. Okay, but I don't think most people, except for the sovereign people, are actually doing that, and they're trying to apply it, and it's just to their own detriment. I'd hate to have someone go into a simple traffic ticket or problem where you could maybe get off, or you have a good defense, and you try these tactics
and just tank your whole shit.
Yeah, let's have you do this next time you, if and when you go into court over any family court stuff.
For the record, I hate courts. Like, it just makes me fucking nervous being in there. Even if I know I'm in the right, I just want to fucking yell racial slurs and cuss words. So they give a breakdown of some of these things. They say you have the right, these different rights. You do, and a lot of this is actually good information. The right to challenge jurisdiction, yes. The right to have your argument of recourse and remedy, blah blah blah. All these things, yes. Here are a few psychological tips. Okay, so remember, I said I was watching this on Ricada. I saw one of the attorneys on there saying this guy is he's used these tactics and he's using them to a T, and it's to disrupt, it's to do all this stuff, and all this disruption is exactly as a survival guide. So I came to this, and then I read this. It says, here you are, Mr. Nice Guy, always polite, diplomatic, and courteous. If you lose your temper or clean language, you lose the case. You are a very smart sheep going into wolf territory. You can say anything you want in court under the First Amendment, but the more you say, the more you risk. The better to ask questions, and whenever the judge hears something from you that blatantly challenges or threatens his or her position as a judge, you risk contempt of court charge. So what we've seen there, the muttering under the breath, the yelling out, do you think he's employing number one of Mr. Nice Guy? Well, yeah, I think you kind of said it best earlier. Contempt of court is just out of the window anyways, because it wouldn't matter. You can hold him in he knows that probably that he could be held in contempt, but it doesn't matter anymore at this point because the charges he's facing.
Completely. So I had a judge once. And we'll keep reading this, people, but we're gonna chit chat here. I had a judge once. So it was a restraining order issue. Opposing party had done one on my client, and the standard is just super easy. It's way too easy to get. It's just there's beyond a reasonable doubt. There's clear and convincing, and then there's it's the one I use all the time. I've been drinking a little bit. Basically, it's a little bit more than 50%. So you just have to be more than likely it's the case. So we have a hearing on this, and opposing party, she's a total whore. She's out all night with her dad's staying home with the kids, and he sends her a text message.
Single mother behavior.
Right. Well, he sends her a message saying, "Hey, I know you're out with your friends, perfectly fine, but we are really low on money. So, if you're going to be spending money tonight out with your friends, we're going to be screwed. So just don't do this." And she presents this as evidence that he was threatening to her. Right. And then, so I'm objecting to that. I'm going, well, obviously that's not the case. This actually shows, she says he's threatening. This actually shows that he's just concerned and, not really even concerned about what she's out, but that she's spending money. And the judge goes, "Oh, interesting." So he sends her this. Next thing you know, it's a little bit pushing. And next thing you know, she's dead. And I was like, I was baffled how he goes from a text that says "don't spend all our money" to he's going to kill her, and so I'm trying to defend my client there, and I go, wow, I said that kind of statement is really hyperbolic to what my client's saying, and the judge lost his shit because I called him hyperbolic.
Was this a male judge or a female judge?
It was a male judge, horrible for that kind of situation, and needless to say, my client and I parted ways. I thought it was best that we did so because the judge wasn't mad at my client. He was mad at me. And I probably wasn't going to do much for him, for the next time. Perfectly fine.
The judge sounded like a simp.
It was horrible. He's super
Jumping
soft.
to conclusion. Is he
Luckily,
gay, man?
He was a commissioner, so he wasn't elected, and so he was temporary. And so I could.
Was he gay? I know you're in California.
Indian?
He was an Indian man?
He might have been. I don't know. So he's not in that courthouse anymore. I did see once, which reminded me of this. I'm in there, and this guy's up there. He's representing himself, and it's a female judge, and she's asking questions. He's being hostile. The bailiffs start walking over, and they're standing behind him. Basically, she told him to shut up a bunch, and then he goes, "Listen, honey," to the judge. "Listen, honey," and he starts going on, and she lost her shit. And then it was funny to watch him back. But he goes, "Look, I've got grandma. That's what I call my grandma." And she was not old. And then she lost her shit once again.
So,
you can't do that.
The times that I've been to court for a family court for my own situation, and then summoned for jury duty, I'm not like, the shit just makes me nervous. Like, I don't like the seriousness of it. Like I said, it just makes me want to yell cuss words. Like, I just want to be able to smoke and swear.
Yeah, it makes me feel that way a bunch of times as well. Okay, let's go through this on some of these other ones.
This seems like I've seen cases where guys like in prison or whatever read and pass the bar, but this seems like some retard shit. Like guys that become attorneys in prison and can pass the bar and beat their cases, but this does not seem like what they are reading.
No, and by the way, that's a good point. That's basically like playing the game, right? I mean, I tell my clients all the time, look, you've decided to bring the state into your case. Now you're going to have to deal with their orders and their rules and whatnot, or, you can try to be this. I would prefer the sovereign citizen type of mentality, but we don't live in that society right now. You're going to have to repeal these things piece by piece somehow, or bomb them or something or other. So,
yeah, I wouldn't want this. I mean, parts of it may be appealing, but like the rest, like the flag shit. I don't know. It just seems retarded. Like even if it was
interesting. So you're big into admiralty.
Okay. I mean, like provide like some of the procedural stuff about record, not like private tape recorders, but like bring someone to record and like have your documents and shit. It's like that's not bad advice, but like it drifts off into like crazy waters and loses me with some of this. Like set a flag on the table and shit. Like even in a private law society, I wouldn't want this.
This is a Alex Jones type document, which I mean by some of it is great info and some of it is just batshit crazy that not even relevant to what we're talking about here. Yeah, come at me, Alex Jones fans. I have a whole thing on him too that I've been planning on doing. Okay, so let's just kind of get back into some of this. Here are some more general factors and guidelines in preparation for playing your winning strategy. Make sure that you are in court of record. So once again, what you said, the reason though, Andy, of bringing your own tape or court reporter is so that the judge doesn't go, they say it in there, doesn't go back at some point and just change what you said.
Yeah.
So I don't find that the judges are that nefarious, but I'm willing to okay, that's fine. Before you say anything else,
he speaks in Ebonics, so they may have to correct the record.
Right, they may have to. If anything else, to ask the judge if the recorder is on. This will then put them on notice that you mean business and will not be hoodwinked. Also,
did Don King write this?
All right. If they ask if you understand, say no. This is a surefire way to control the case and to employ the best strategy described here. If you answer yes, you're giving up your Sixth Amendment liberties. Just say no and use the opportunity to embarrass the judge into admitting more of the truth, the law, judicial decisions relating to your lack of understanding. Yes and no. Sixth Amendment is your right to confront witnesses, to have a representation, and by that it also means self-representation. So okay, I don't know where the Sixth Amendment comes in there, but okay. And the judges are triers of the referees in a sense, right? So they're not going to explain the law to you, and she's done on many occasions not explain the law. Like you just have to figure it out. Admit nothing. Ask questions. Every question you answer in court digs you deeper and deeper into the jurisdiction hole. Your answers automatically give you implied consent to the court's jurisdiction and authority over you, and everything you say is already being used against you. You're trained, just like the officer, to get to admit things that incriminate you. So it is in your favor to admit nothing. Keep asking questions. This will control where the discussion and evidence is going. So that's kind of bullshit, because once you've submitted to the appeared in court, unless you do a special appearance. So a special appearance would be like, you file a case against me in Texas. There's no standing whatsoever or like jurisdiction for that. I've got to show up though, so that you don't default on me. And so I do a special appearance to basically object to jurisdiction. Court then kicks it out. The special appearance doesn't mean that you've actually appeared, if that makes sense.
Yeah, you can send representation there on your behalf.
Yeah. Like I could appear as counsel. I've done that for people in my jurisdiction where I practice. Special appearance, it's not considered an appearance, because once they've appeared, now you can default on them, or the court has jurisdiction over them by that. So this is what they're saying. Yet he's appearing, and he's not. He did say he's specially appearing as a third party intervener. I think it doesn't. He's. He's still there. Act dumb, play smart. He's done that to a T. Smile, give thanks, apologize, and ask. Bait, steer, and corner. These are all odd things. So let's keep going through some of this here. So some of this is like knowing your motions, knowing what to do. He's got some trouble with that. Don't let them rush you through anything. Don't agree to anything that you don't understand. Objection. So this is one aspect that he's doing quite well, which is, when I say quite well, I mean like over the top. He does it all the time. He objections through the roof. Let's see if we could actually find some of these. Let me pull this one up here. How you doing, Andy? Still hanging in there?
I'm good. Emma's still just coloring. I just hollered at her.
Okay.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or me?
I'm sorry, I did not hear the question.
Okay, let me explain. That's fascinating. So let me explain what his problem is. The witness is probably a police officer, and he's probably been in court more times than this guy has. So he knows to talk to the jury. That's just what you do. You have a connection. That's really who's going to make the decision. So I just caught this. The guy's talking to the jury, and so now he's pissed off that he's looking at the jury. So let's keep going here. Look at the DH. You're like, what?
What I was referring to when I asked a question, he turns towards the jury as if they're the ones asking the question.
Oh, he said asking, so he doesn't know how to say that word.
That's not a question, Your Honor.
It is a question.
We did ask a question about that.
Yes.
I think you're asking why does he do that to that extent for witness names?
I'm here to present the case to the jury.
So I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes fact, not evidence. Sustained as to the form of the question. Please rephrase.
I just remember the media covering for this guy so hard.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative still assumes fact, not evidence. Sustained.
You made reference to you being here to present the case to the jury.
I want to put my tinfoil hat on. All right, so you remember the media would
So
never
is that the
say
reason?
his name, and they would only list the vehicle as the murderer.
Yeah.
It almost like lends itself to this sovereign, like they knew he was going to make this sovereign citizen argument.
Yeah. So what cracks me up is if you think this should have been in Darrell, is this being covered at all by the media? I don't watch it. So, Spud, I will say that on YouTube and with the media, it is because he's so outlandish and crazy that you can't help when he's yelling at a judge, don't disrespect me. And it's just amazing stuff that anybody would, an attorney, even partially doing some of this once, you would be kicked out, then sanctioned and you'd probably spend a night in jail. That's literally, that's one of the options for contempt could be, citing you or holding you in jail until the judge decides. That would definitely be the case if any attorneys acted like him. But once again, we've talked about what can she do? She needs to get through this. You need to convict him so he can burn and rot in hell. So you've just got to kind of be this. But since it's so outlandish, the media is somewhat covering it. At least to me, they are. He wanted to make a racial thing out of it. I guess his Instagram and some of his social media, that was another thing that his former attorneys were able to get quashed or like not coming in. But evidently he was pretty outlandish, racist as well. And I would have loved to have heard all that stuff.
What kind of racist, Tyler?
He probably hates Eastern European white people. I think that's let's just go down that route. Let's keep going.
Why you decided to testify?
Objection to the relevance?
Grounds.
That's what he says all the time.
Overruled, the witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor. Sustained. Next question, please. Or rephrase, though. previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection, argumentative.
Grounds.
Sustained as to the form of the question. Please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
The objection is sustained.
This is
Back and
maddening.
ask the question that he says he didn't understand and rephrase it, please, or move on.
This is like having black mutualists on your
Your
podcast.
sole reason for testifying here today.
Objection, relevance.
Let's let Mr. Brooks get the question out.
Oh, look at it.
Oh my
Well,
God,
Judge,
that
I thought
glare.
Are you testifying today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds that that's what he said.
Okay, let's just go on because he's not really helping us here for that. But you can see the problems presented by this gentleman. You know, the problem that I have in what I actually do is oftentimes people are self-represented. So I actually had a trial, it was a week ago Friday, and it was against a lady that was self-represented, and it was a mess. She came in there loose papers, and it makes it so difficult because even the objection, those kind of things almost go out the window, right? It's just like, it's chaotic. The judge tries to help her. He then ends up asking a lot of the questions. So he does a lot of the work that he's, you know, you don't have a jury. It's just a judge. So you don't have to walk through a lot of the stuff to explain to the jury, you know, the situation. He understands a lot of the legal stuff. But anyway, Kate says, I haven't been able to stop watching this train wreck trial. Same. But Kate, let's now join into your possibilities if you go to court and you're a sovereign citizen. Objections. Don't let the judge or prosecutor get away with interrupting. Now, he's really read that part because he definitely has. The court made a judicial determination that I am not allowed to defend myself or that I cannot have freedom of speech in this courtroom. Part of the problem is just decorum for him. He doesn't understand this, and you know, he actually is. He said the other day, "Is that a lawful law?" All right. So
yeah, this would be like me trying to represent myself. I would fail miserably.
you would do fine, because you would understand it. One of the things I try to do all the time in the courtroom is, and I tell this, and clients don't always understand this, but I'm in the same court all the time, so you get to know how judges work. And sometimes when a judge is starting to say something, you're like, okay, he's made, or he or she, they've made their decision. Me pushing the issue more is not going to do anything. Matter of fact, it may make it worse. Okay? Yeah. So sometimes I'm like done, or I realize we've already got this in the bag. I'm not going to make any more arguments. And then I've had clients that get all upset about that. And I'm like, no, you got to understand where it is. And then if they push it, they understand. They start to get the ramifications of the bad stuff. So let's see.
No, I'm just saying I could understand the decorum, but I would botch all of these legal arguments. I would just, me trying to represent myself, I would be the loose papers, botching my arguments, and I wouldn't be cussing at the judge, but
right,
I would want to.
Some of these examples: allowable jurisdiction given by the U.S. Constitution, Article 2, Section 3, Section 2. The judicial power shall extend to all cases in law, equity, and admiralty jurisdictions. There you go. That's right. But the 10th Amendment gives states power to determine anything else. I think that's what it is, which one it is, which then the states have a constitution about jurisdiction, and they are the ones that have the police powers. So you've got all kinds of problems mixing with, if it's just a federal issue, perhaps you're, whatever. But then, and then there's federal jurisdictions, which are completely different, and there are maybe a little bit more specific. So,
yeah, I'm sure he's got a ton of state and federal charges on this.
Well, the feds didn't bring anything. I mean, but there's like, I think 70 some different charges.
Okay.
Yeah. But this whole document talks about it says, playing dumb early and then coming on strong with when you kind of lull them in to a sense. This guy's not doing any of that. I don't think he's followed this to a T, and he's just shown himself to be a complete.
Well, he's followed parts of it to a T.
Right. Yeah, that's true. There were some other good portions in here. Okay, so let's talk about this. Strategy 1: stand on the Sixth Amendment and expose the truth. So he's really pushed on the Sixth Amendment at times. This is by far the most effective and successful strategy we have seen. And it is simple enough for anyone to master, but there are some details that you will have to know cold. Here, you are using the fact that they can't reveal their own fraudulent admiralty jurisdiction. Once again, admiralty, is that the courts of the sea? Is that, I don't know if that's what they're talking about. We have to look at that. That's maritime law. What's admiralty? Your admiral is a leader of the Navy, right? What's admiralty law? I don't even know what admiralty law is. Let's look it up. Okay, here we go. Admiralty law or maritime law. Okay, I don't even need to read past that anymore.
Okay, so I was right.
Yeah, me too. I'm like, okay.
Yeah, I've known some schizophrenics.
It is in their most important secret to protect and keep off the record. Most of them are in fear of losing their licenses and jobs, for they have all been secretly sworn by the bar never to reveal it in open court. But I'm sorry, that cracks me up, because why would you? Here's something you're never going to reveal in court, and then they give it to them, or you just don't ever mention it, and they just don't know, and then they don't mention it and talk about it in court because they're not even aware of it, right?
So, is this lawyers have like a secret backdoor handshake or something?
There's a lot of backdoor stuff going on. Yeah. It is sovereign argument valid? Kate asks. I was confused about jurisdiction part. He keeps bringing it up. Okay. You missed the first part of that, so we'll talk about that once again. No, it's not valid. There's that. What he talks about, he keeps bringing up subject matter jurisdiction. And I talked about that earlier. Hang on, we got another. As an attorney, can you suggest the jury practice jury nullification, or is that grounds for immediate mistrial? I believe you can do nullification. I don't believe you can necessarily pronounce that's what you're doing. So you just nullify it.
Could you do it as a juror to other jurors?
I think that's what you're talking about. I don't think as an attorney you can announce, like a defense attorney, that you can nullify the law. I don't believe that you're going to get away with that. I don't know about juries in the jury room being able to discuss that either. I think you could they might say it's jury tampering of some sort, but you can. I mean, for the most part, as a juror, you can do that. I believe, I don't do criminal law, so on me, but I don't believe you're able, or the judge will allow you to say that you can nullify. I do believe you're able to do that. You should be able to do that as an attorney, but it's what it is. Just go back to subject matter. He keeps talking about subject matter. Okay, wait. Hang. I don't think you're allowed to talk about nullification in a courthouse. Could be true. You know what? Next time I'm in the courthouse, I'm just going to talk about it like in the back room, where us attorneys talk about stuff like that. and then I'll say, take that, Kate. I did talk about it. I didn't get hurt.
At the secret bar exam.
Right. Bar. Subject matter jurisdiction. There's two jurisdictions. We'll go over it real quick again, Andy. Personal jurisdiction, which is, do you have minimum contacts that they actually say it's you that they can bring into the state in a court case? Subject matter is the subject itself, civil, criminal, admiralty. And most courts are of general jurisdiction, which means they can handle all of that. The federal courts are the ones that are under limited jurisdiction. The other ones have plenary power. And she says, please do and report back. Yeah, I'm going to court on Monday. I'm going to fucking say nullification somewhere. My client doesn't speak good English, so I'll just say it to him, and I'll probably get away with it. What do you think about that? Sounds
what
good.
Kind of English? Is it nullification, or is it? Is it more like Daryl Brooks English?
He's I need a Spanish interpreter. That's just what I'll say.
Okay.
Yeah. Stand on the Sixth Amendment. That's what we've got. Most of them are in fear of losing their job. Okay, we already talked about that. But this strategy, you have to reveal it just to proceed with the case against you, because you must have answers to your questions. It is the duty of the court to inform you of the nature of the cause of accusation, Sixth Amendment, and this is your greatest strength. Not really. I don't. Do you see any holes there? Should we look exactly the wording of the Sixth Amendment? Do you know it?
No, I don't know the exact wording. I should, but I don't.
I mean, it's the ability to confront your accuser and have an attorney, I believe. In all criminal prosecutions, accused shall enjoy the right to a speedy trial. Okay. And some of them public trial. So one, speedy is to be when they talk about when you first go into court and an arraignment or getting to the next step, you can waive it at that point. And that's basically, they have to present it. And that's usually the state holding things up. But if you need more time, you waive it. And once it's waived, you're kind of past that. I think that's 21 days or something like that. Oh, I got it on this other one. Speedy trial, public. It's on live stream. Impartial jury. Okay. He would have made it in the state, in the district wherein the crime has been committed, and which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the action, to be confronted of the witnesses against him, and to have compulsory process, obtaining witnesses in his favor and assistance for counsel for his defense. All of that. So I think the problem that they have there, that they make against that one, is the district, the crime has been committed, which district shall have been previously ascertained by law, and to be informed. So that may be their gotcha on the Sixth Amendment issue, which I don't know.
Yeah, if you're taking the admiralty route, I guess maybe like I need to be trialed. This trial needs to take place in international waters or something.
Right. So this is what I wanted to get at. So when you're asked if you understand the charges against you, you must say no. Okay, Andy, you've been accused of buggery. I think that's a backdoor action, or is that with sex with a horse? I don't know. One of those two. Could be both of those. You will be standing.
Driving a horse.
Right. So you've been accused of buggery, and you say no. Okay. You would be standing in your Sixth Amendment right to be informed of the nature and cause. Okay, Andy. Well, you had sex. I think buggery is just ass sex. Then you would be steering the judge through a very careful series of questions about the nature, cause, and jurisdiction. You're going to force the judge to expose the court's fraud in order to proceed the case against you. The judge will have to dismiss the case. There you go. There's no simple other way around for them to deal with this strategy, provided you stand your ground and you're going to be real polite and courteous. So he's not abiding by that part.
This seems like as believable as like the astrology, like witchcraft, like just say this spell.
Well, it keeps going through. Right, it keeps going through different scenarios, and it's like keeps saying, and the judge will dismiss the case.
Yeah.
You have to ask if you understand the charges. There's no way around it. They cannot legally proceed against you until you acknowledge the charges explicitly and their jurisdiction explicitly. Well, not completely. You can be tried in absentia, but she keeps saying, do you understand them? And he will say things like, he doesn't say understand. He tries to work his way around that. The 6 minutes says that you have to have a right to know. It doesn't mean that you have to consent to them. It just means that you have to be told about it. The authority requires the court to explain. The court has a duty to explain. So by your declaring you do not understand the charges, you will steer the court into a legal position where they must answer. Oh, they've already said this. So
they're only obligated to explain it. They're not obligated to make you understand it.
Yeah, that's right. And I think their idea too is that if you're going to be, well, there's all kinds of ones. You're pro per, which means you're self-represented, which means you're not subjecting yourself to the jurisdiction and being so I, as an attorney, I'm an officer of the court. Okay. I have certain duties and obligations as represented by the bar or a member of the bar. And I have these obligations when I go to court to my clients, blah, blah, blah. And to the court, they're saying, if you pro se, you are then acknowledging and consenting to be that. So you go pro per. Now, in different, it doesn't matter because different states and different jurisdictions, they call them one, the other call whatever. And so he wanted to do this. He wanted to be pro per so that he's not subjecting himself and consenting to the court, and he's not an officer of the court at that point. I don't know, Andy.
Do you think, and he'll probably try to appeal this, right?
Yeah. Once again, just like everything else, he's got nothing to lose, so he can
Or do you
appeal.
think?
Yeah, he's not good, and that's why I'm watching this, seeing that the judge is at some points. It's a teenage. You'll have this when your daughter gets older, which is she'll be a teenage girl, and something will go wrong, and she'll argue with you, and her emotions are high, and you will just say because, and she'll keep arguing, and you'll just, do you lay down the law? And maybe, I mean, it depends on how your relationship is and what happens. This person here let's say that her mom is the opposite, right? Emma's, and you're worried about some sort of conflict on custody, right? So you don't want to go over the top and really lay down the law like you would like to, okay? Because it could come back and hurt you. That's kind of how this lady's acting here. She's like, I want to just lay down the law, but the other parent, which is the appellate court, they may overturn this. And so I got to give all the deference I can. And this child is just going to act the way he is. And at some point, it's going to be understood. So
Yeah. Do you think he'll try to plead insanity?
No. He's shown in this as an example. There's incompetence too, right? Of counsel. They've already declared that he's okay. That's the whole process that they went through to make sure that they did a psych eval on him. And I think hang on here. They had some sort of determination that he has all the markings of a serial killer, but he's not mentally deranged. So he's, at least able to handle himself. There's the competency part, competency of counsel, but he's made it. I told you before, there's this case called Illinois v. Allen, which talks about the three options that the court has and more. It says 3 options and more. And he was able to he knew these 3 about contempt, binding, gagging, and so a few other things you can do if there's so he's able to comprehend these things. He's able to have cogent arguments at times. He's not insane. I think he's already gone past that. That's why they're being able to try him. That's the way it is. So I don't know if there's anything more really on this this whole guide. So I don't know. What's your feelings about sovereign citizens and going to court?
I'm still curious if there's ever one that's slipped past and worked. Like, is there a single time that this has worked in legal history?
I would say yes, inadvertently. I can't prove this. This is my guess, which means someone got a traffic ticket somewhere, and they went to court and they made this claim, and then the officer never showed up, and so they dismissed it because of that. The other one, and it's like, oh, it's because I'm a sovereign citizen and I showed my flag. The other one is like, they went and did this, and the court's like, oh, let's check on jurisdiction. Oh, maybe it wasn't the case or something happened. So they actually dismissed it on jurisdictional issues, which you can do, not because he was a sovereign citizen, but because the jurisdictional requirements were never met. I bet that's happened. Otherwise, it's just like Wesley Snipes. Hey, I'm not filing my taxes. You don't have that jurisdiction over me. And the IRS says, okay, whatever.
Yeah.
Sorry. How many years in jail do you want to do? So.
Sounds about right.
Yeah. That's my understanding or my feelings on it. So, yeah, that's pretty much what we had. I don't think, oops, let's remove this. Anything, you want to play any more of his issues? The only other issue I was going to talk about, maybe you want to do this if you have some time still, is the Alex Jones stuff.
Sure, we can talk about it. Let me yell at him and just double check and make sure he's all right.
Okay, let me pull some things up while you go and do that. So maybe you guys know this. Alex Jones lost 2 cases. We had Hornberger. What's his name here? Jacob Hornberger. He ended up writing something, what Alex Jones deserved to get the basically. What do you say? Alex Jones got what he deserved. Part 1. We'll bring this up. Okay, so here's the article. It's on, is it on Fee? Yeah. Future of Freedom Foundation, the Triple F. Alex Jones got what he deserved. And Jacob Hornberger, who ran for president for the Libertarian Party, and he did not make it. He was endorsed by the Mises Caucus. It did not work out so well for him. And so he wrote part 1, part 2, part 3. This other one, part 0, deserved what he got. I guess that's just a kind of a web or a video that he did there. So he's saying, look, he talks about torts here and defamation case. I have some issues with Alex Jones. I don't think this is saying naughty things are enough for defamation. And my real big issue here, though, I've said this for many times, is Alex Jones, I think, had some shitty attorneys. Okay. And what made me think of that? And by the way, I've gone through the pleadings. Andy, just say, chime in when you come back if you are. Okay. So First Amendment Watch, Jacob Hornberger writes here, he says, on Monday, November 15th, a Superior Court judge in Connecticut ruled that conspiracy theorist Alex Jones was liable by default in a defamation lawsuit brought by the parents of a Sandy Hook Elementary shooting victim. Judge Barbara Bellis issued the default judgment after years of Jones's refusal to turn over financial and web analytics data that had been ordered by the court. In her ruling, Bellis criticized Jones's attorneys for providing only sanitized, inaccurate financial records and showed callous disregard for her repeated rulings to provide complete analytics data. She found Jones's attorneys' actions were not just careful, but constituted a pattern of obstructive conduct requiring most severe sanction of default, which she called the last resort. Okay, my problem with Jacob Hornberger is he took a citing in his post by another blog stating why it happened. I have gone through extensive reviews and trying to find the actual pleadings in the case. I see the order. I found the order from the judge stating that she was going to default. So what is a default action? You file a case in court. The other party responds. At that point, they've got to go through a trial or an agreement, settlement somehow to get a resolution. If they don't, well, that's only two ways to do it once the other party responds. That response could be their appearance in court. It could be filing a response. So it just depends on what that is. But the appearance typically is, once again, a response is showing up in court and appearing and consenting to the jurisdiction of the court, and or actually filing the response itself. Okay, Alex Jones, they filed the response. If you don't file a response, the other party has the right to have the case heard. And so if you don't participate automatically or just voluntarily, and you've been served, then they can do a default judgment against you based on the fact that you are not participating. Okay, the parties in Texas and in Connecticut filed the suit. Jones responded, and then they got a default judgment anyway. How does that happen? Well, they had done massive discovery requests. Discovery is, I need documents X, Y, and Z. You've got opportunities to object to those, but there's the rules of civil procedure are pretty specific, and the damages or the remedies for them are pretty specific as well, and they use the outline. So I've had this many times. You're in court, you have a case with someone else, they ask for bank records or whatnot. So they give you a formal discovery, maybe a request for production of documents, and you have to respond within 30 days plus 5 days for mailing from the time that it was mailed out to you. So you just do that calculation, 35 days, boom, here's when they're due. When they're coming up, if you haven't been able to get them, you can ask the other party for an extension. They can often do that. Sometimes they say, okay, well, I'm extending this, but by the rules of civil procedure, I'm going to say that you then are going to give them to me without objections, or you don't respond in time. and then they have to do a motion to compel. They have to force you to give those over. The judge is going to say you don't get to make any of these objections, like because you can object in your discovery response saying, I'm not giving these documents over for whatever reason, relevance, whatever the multiple different types of objections you can do. And then if you do give them over, or let's say you provide them, if there are objections, then the court would rule on those and determine whether you have to give them or not. So that's one aspect. The other one is you give them all the discovery. Maybe you didn't comply with it very well. And then the other party has to send you a statement stating what is not in there. So they can't do a motion to compel until you've tried to give discovery. And we do that sometimes. It's like, I got a shitty client. They're not really paying attention. I'm like, hey, we've got to get them these documents. And at some point they've got to, here, we'll just do this, giving me the documents. They're not giving them giving you the documents. So you just, or they give you a few of them. So you respond in time. Now you've quashed basically their motion to compel. And then they have to send you a letter saying, hey, here's what was not outlined in there. And then you've got to kind of provide all that stuff. Andy, let me know when you're back in.
I'm here, but I didn't.
Okay.
I was focused on Emma for a little while, so I missed why you said Hornberger. So
I was going through I was talking about the Alex Jones thing, and I'll just revamp it here just real quick, which is he got defaulted on in Texas and in Connecticut. Okay. Mm-hmm. And you know what a default judgment is. Basically, if you don't respond, you can still force the other party to participate and get a default judgment. That's what happened. But he did respond. And so I've gone through, Jacob Hornberger has mentioned here another blog that said, oh, he didn't comply with discovery. I listened to Robert Barnes. Robert Barnes is like, we've given all the discovery documents and more. It's so much more. It's insane. And they went ahead and gave him a default judgment. Okay. I've looked on the pleadings. I've seen the order for the default judgment. I've not seen so typically for the default, the plaintiff is going to draft something and submit it to the court requesting this happen. It's like a death knell type of last judgment type of order that they would do for not complying with all the discovery. I would like to see Alex Jones' attorneys reply, because they should show in there everything that's already been submitted, whether it was done in time, blah, blah, blah. So that's a step that I feel like is an incongruent answer that I'm not seeing, because I don't know if Alex did comply. I see that his response, or the court's ruling, basically says that he didn't do it in time. So they said it's due by whatever date. He didn't comply with that. He kept getting pushed out and pushed out.
I've also seen that part of what they were asking him to submit to discovery was just mountains and mountains of stuff that is almost impossible to provide. I don't know if that's true or not, but.
So I was just describing before you came back, which is there's the best thing usually to do for attorneys, and his attorney should know this, is you comply by the date set. Okay. Yeah. So and it sounds like to me, and the judge wrote in their answer or her ruling that he was late. He was not complying with the time constraints. So you can ask for extensions on discovery dates of time to comply, but they went and said, okay, well then you waive all your objections. Okay, because that's the case. So my point is, you get them what you can by the time it is set. Then they've got to reach out and say, okay, you didn't give us X, Y, and Z, and you can object. Anyway, so there's all these kind of things. I don't know that the judge made rulings on anything other than the default judgment on that. So there's, to me, some skepticism. Jacob Hornberger is a kind of a piece of shit, though. He said, I just don't believe that, one, this was a defamation case. Two, by the way, all the courts that I work.
Cancelo's response was pretty great. I mean, from a libertarian private law perspective, I mean, Alex, I understand that we're like, defamation law is a thing and you can sue a ham sandwich.
Right.
But, as a libertarian, you should be advocating for private law. And as far as I know, Alex Jones didn't violate anybody's rights by simply questioning the case or even saying inflammatory shit or whatever.
Right. And as a matter of fact, Robert Barnes, the attorney, has pointed out that Alex Jones, one of the people that sued him was an FBI agent. Okay, and won $90 million. That's just insanity. So there's a lot of problems I have. One of the issues it was, though, you probably heard about all these records that got discovered or sent out to attorney by mistake. I don't know if you heard about it in the Texas case. There was emails, text messages,
wife and stuff.
You're right. So the problem with that, and this is why I say he's got shitty attorneys. There's like a 15-minute clip. You can have a hearing where Alex Jones has already testified. They already had, because by the way, the trial was only over damages. And so that was completely it. And I suspect there could be some, if Jones is right about him doing discovery and they still did this, then these would be overturned. But they gave them all their files that they weren't supposed to give him. And so then Jones, it's already in there. They're already doing a trial over it. They say they already have all these documents. Then midway through this trial, his attorneys.
We have the documents.
Well, they said they had, yeah, exactly. Then Jones's own attorneys are like, oh, this is attorney-client privilege. There's other stuff in there, and they're objecting to it. So the plaintiff's counsel comes back and says, okay, that's great, but you sent us this document. We sent back and said, you've accidentally sent us everything. Here's the law in Texas dealing with civil procedure. Civil procedure laws are pretty distinct and specific. It says you have to do X, Y, and Z within a certain number of days, or all these documents are considered ours. And his attorneys didn't do any of that. So, and they produced emails and communication where they were saying, here's what we asked you to do. Anyway, so the plaintiffs, shit that they are, they still comply.
Why doesn't he have Robert Barnes representing him?
I don't know. There was some problems. Barnes was not in the case at this point. So I don't know. My point is, I'm watching this and I'm looking at them getting shelled in court from being shitty attorneys. And by the way, I wouldn't want this job for them, but I was just like, it's hard for me to. I get it how it went here, but when I see this simple thing, and that the opposing counsel was able to produce documents outlining the rules that they were following, and you had so many days to like do something about it, and you didn't do it. How do I know that if that's the thing that you missed, then you probably missed a lot more? Now,
yeah. What do you think? Like, made Alex Jones hire these attorneys? Like, do you think it's just like he's got too many like yes men around him, or he's just got too much other shit going on? And
maybe it's like Trump, and he goes, who's on Fox News? Who's a great attorney on Fox News? And then he uses that. And the reality is, you probably don't want those people that are necessarily on TV. You probably want someone that's focused on actual, doing the job. So
yeah, he's got Sidney
is
Powell
weird
or something. He's trusting the plan.
Right. It is weird that you had two states, different jurisdictions, with the same exact ruling. That to me doesn't help me. It makes me more skeptical against Alex Jones than like for him. And I think, the ruling itself was ridiculous. I mean, there's two types of damages: compensatory and punitive damages. Compensatory damages are just to compensate the victims and kind of like a calculation of what you would have from the damages they encountered. And then punitive damages are usually much higher and a little more discretion to punish the party for what they did. The $90 million was just compensatory. So that's.
So are we getting to punitive, or is he going to face punitive charges on top of that?
Yeah.
Good grief.
That's in Connecticut. So he was capped in Texas. So.
Yeah, and I did hear something about like, they can set it this high, but he might not necessarily have to pay that amount or something. I'm not sure.
Texas, there's a limit. So I think it's 5 million is like the cap, but I don't think there's a cap at all in Connecticut. So he's somewhat screwed. And that's, that famous court case where there's like millions of dollars for a spilled cup of coffee. I mean, that got overturned or remanded back. And I think it was like 200,000 eventually. So, things happen.
Yeah. I mean, they're hitting him with, I don't like any of these laws anyways, to begin with. This defamation, or what was exactly his charges is like.
What do you mean? Who? Alex Jones?
Yeah. What were his? Okay, God.
That Spud just sent that to me. So, well, it was defamation. So
Yeah.
there's a lot of problems, and the media cheering that on is pretty wacky because that could be them, and it won't be, but it could be.
Yeah.
Does the Texas law still halt in Connecticut since he is a Texas halt? Whatever. I thought I heard Barnes say that. I'm not sure what you're saying there. Maybe you could rephrase that again.
I think this is why they tried him in both, in Texas and Connecticut, right?
Right. So you can try someone, and they have to have. We just talked about in persona jurisdiction, which means that person has to be. You have to have minimum contacts. So the statements were said in Texas. He does business in Texas. Therefore, that's what it is. The incident took place in Connecticut, and they probably argued to get jurisdiction over there. They probably argued that they were on TV or in the news there. So once again, it's defamation, especially in this day and age. It's pretty easy. Johnny Depp, as an example, that was in Virginia, I believe, West Virginia, one of those over there, because that's where, or Maryland, maybe. Anyway, that's where the publisher was for the Washington Post or Washington Post. So they were able to do it there, but it could have been anywhere because it was disseminated. Okay, he says, does the Texas cap still stop him paying so much in Connecticut since he lives in Texas? Barnes said something like that. I heard what Barnes was saying, something like that as well. I don't think he said that it would stop the cap from happening because that's a different jurisdiction. So I don't believe that would be the case. Could be. I don't know. I don't really do that kind of law. So I'm just speculating here. But I hope that's the case. I'm not a big fan of Alex Jones and a lot of this stuff, but I think this is I'm not a fan of any of this defamation. Andy, before we'll head out here. What did Kinsella say to Jacob Hornberg? Because I think Jacob's shit was kind of shit.
I think it'd be interesting to pull it up if you want to go through some of it. He's got a decent tweet thread just about, how defamation isn't really a rights violation. He wasn't aggressing on anyone just by simply questioning or being inflammatory.
Yeah, I've got it here, actually.
I mean, he wasn't violating anyone's rights.
Okay, so normally I like and agree with Jacob Hornberger, but this is the worst thing I can recall ever coming from his pen, typewriter. H has gone off the rails here. This is not a libertarian perspective. For one, defamation law is totally unjust and unlibertarian. Two, this has been known for some time. Rothbard, Block. Now, Block did sue the New York Times, right? But for defamation. Also, libertarians are not in favor of the state's law on torts. Just because they call it a tort, intentional infliction of emotional distress is not a legitimate tort. Agreed. Rights are violated only by invading borders of or affecting the physical integrity of owned resource, period. And then he gives his own writings there. And finally, the fact that Jones was aware of the existence of these unjust laws. Yeah, that doesn't make sense. Also doesn't mean that he got what he deserved. Yeah, that's ridiculous. Also, we know that drugs are illegal. Does not mean that people locked in prison now for possessing cocaine just got what they deserved. No, I was not aware Jacob was bad on defamation, bad on torts, and leaned towards legal positivism and victim blaming. This is disheartening and dismaying. This makes me suspect Hornberg is also pro-patent and copyright, IP, or intellectual property, since this is what legal positivism would lead you to, and also defamation is really a
Do you
form
stutter
of
this
IP.
much in court?
I use words I know, which I don't really. Supports plus IP is in the Constitution, so he is a Constitution-supporting minarchist, probably influenced by Ayn Rand, probably supports IP too. If so, sad. That's a very it's very
Kinsella is actually influenced by Ayn Rand as well, but I don't think in this regard he is.
Right. So yeah, it's good stuff from him. Okay. So we dealt with some law on a Saturday night. How does it make you feel? A little gross?
Well, hanging out with you for almost 2 hours, I definitely feel gayer.
Okay.
But it's always enjoyable.
Yeah, I feel bad. My wife's in Seattle. She went up there with a friend, and then during this whole thing, she's been texting me, and then she just said, "Why are you so distant?" And I'm like, "I'm on a podcast with Andy." So that. By the way, did you see the text Top Lobster or the tweet Top Lobster did about me?
Yeah, yeah. So I replied that that's my gay dad.
Right. So I thought I'd just show everyone here. Add this to the stream, and it's a picture of me, obviously photoshopped on the Halloween costume. My wife thought that was funny enough to send that to our kids in our family group chat, and they love it. Sad.
Hey Emma, come here real quick. I have her do my plugs.
Okay.
We'll see what
check
she
us out
says.
we're on Rumble. Let's start building this shit up, and we got to get at least 100 subscribers over there so we could do live. I've actually liked their system. Dan David said, "I don't know how I feel about Consola. He blocked me because I called him out for being a holier than thou and having gone to college." Just on Consola, he had a bad take during COVID about some vaccines, and everyone was jumping on him. So I can see why he might have blocked you for the, not that what you were saying was wrong, David. Let's hear it, Emma.
Kinsella is an agent of chaos, and David Brady, you deserve to be blocked.
Yeah, we'll have Kinsella on here shortly, right?
Hopefully.
Right.
Hopefully.
Hey, by the way, for the Kill Pod, I was thinking of, yes, Emma, I was thinking of having Zach, the Unfit Statesman, join us. What do you think? Because Robbie
That'd be cool.
Okay. How you doing, Emma?
Hi.
Hi. Do you skateboard like your dad?
Yes, I do.
Okay. Is he very good?
Yes.
Okay. That's all we need. Where can we find Andy online? Do you know? Your dad online? Is he on TikTok? Okay. No, he's not on TikTok. Okay. Is he on Instagram?
Where can they follow us, Emma? You can say whatever you want.
On the internet.
On the internet.
All right. The dark web, probably. All
right. You want to say bye to everybody?
Bye.
Bye. Okay. Thanks, Emma. Thanks for letting us have your dad for a few hours. All right, everybody. Once again, Tyler and Andy, we're going to do a Kill Pod coming up. I'm going to put our descriptions in there for our Rumble, Odysee. Go follow us on all those spots. Whichever one we can build up the best, the better. So anything before we go out, Andy?
No, I'm good.
All right.
Do you want to say anything, Emma, before we go? Yeah? What do you want to say? Being shy.
Okay.
All right.
You have to get that game up. Okay. Goodbye. For when she gets on TikTok. So. All right, Andy. Thanks a lot.
Later.
All right. Bye. Uh-oh. Hang on. Out. There we go.
Okay, I'm leaving now. Bye, guys.
But she's back.
Chick-fil-A is completely overrated. It's not that good. I prefer Zaxby's. I prefer Popeyes.
Takes a tough man to make a tender forecast, Nick.
And I guess that's me.
Keep fucking that chicken.
Should I vote for Dick Cheney on the Libertarian Party? Do I have an obligation to vote for Dick Cheney?
I would say so.
Yes.
Did it work for those people?
No, it never does. I mean, these people somehow delude themselves into thinking it might, but it might work for us.
That one dude was like, not a podcast. I can't find it anywhere. They don't have video.
Oh, yeah, Peter Janke. Yeah.
Yeah, I blocked him.
I'll do it. If he unblocks me, I'll...
He'll buy your shirt if you unblock him, Bert.
He's a wigger.
Yeah, nothing cooler than a 49-year-old wigger. I just started live streaming. Cut me some slack. I'm pretty high tech for a boomer. But anyways,
boomer.